organization was helping, you know, with the development of Africa and Asia and these underdeveloped countries. And you know, the International Monetary Fund does nothing but wonderful things globally. Well, that all sounds okay until you read John Perkins' book, which was a New York Times bestseller, called Confessions of an Economic Hitman. In that book, John Perkins, who was right there doing that stuff, you know, will tell you that they're involved in murder, extortion, and everything else. Okay? Because they can go to some banana republic and talk to the president there and say, I've got this trunk here with $10 million in it for you personally. If we can help your country with a multi-billion-dollar loan at just 1% interest, which of course they lend them the billion, but they don't lend them the 1%. So what happens? They have to default, right? Because they can't possibly pay back the interest because it doesn't exist. So, you know what I'm saying? If we have these green pieces of paper and we call them foxes instead of dollars, and put them out there, give them 10 million of them, or 10 billion, or whatever, but I don't give them the interest, all they got is that. And they can't possibly pay back the interest. And then when they default, the International Monetary Fund says, oh, well, we'll help you out, we'll bail you out. Sign here, we'll lend you another 20 billion or whatever. And, but of course it has to be at a higher interest rate because you're not really creditworthy, but we're really helping you out. And so they lend them more to bail them out, and things just get worse. And the fine print says, you know, when they came to them in the first place, by the way, they'll say, well, you got gold mines that went into the country and oil wells, oil in the ground at the other, but you don't have the infrastructure. You don't actually have the mining equipment. You don't have the drilling equipment. You got all these forests in between, but you got no highways. You got no hydroelectric. We can fix that up, you know. And they do all this stuff, and they got the stuff started. But then the country defaults on the loan, and they say, okay, well, we'll lend you more and bail you out. Sign here. And the fine print says that the natural resources go to the International Monetary Fund. And you may not have been aware of it, but they've been doing that here. And what they did is they took from you the national parks. Okay? And they've already issued things like passports to visit the Grand Canyon. How about it?
They can't take it anywhere.
I wasn't going to run my mouth today, but you provoked me.
It's all my fault?
It's all your fault. And you know that the mayor of Boise, Idaho has given the Chinese a huge parcel of land next to the airport so that they could land their planes there and build a little city there. Boise, Idaho is where it's right on the Snake River. And where do they come from the Snake? Where does it go into? The Columbia River. And if you were going to come into this country, how would you come into the country if you were a trucker, like I was, I could keep my money and I couldn't get it. You probably delivered some containers to either Seattle, Los Angeles, or Portland, Oregon. And they have huge storage areas for these things. These storage areas where they'll take these containers, as you've seen a container train go by on the way in here, they'll pack them, they'll stack them 6 and 8 high. Now if they were stacked with munitions and people, and all of a sudden one night the doors opened, and they started up the Columbia River, killing everything they saw, which is what they're going to do. They're going to do that because it's the easiest possible way to get into this country. And we'll run down the Columbia River. Maybe we'll be able to stop it. Maybe we won't. Another comment in regard to what you said. I have a friend well, first of all, my first sergeant in my outfit overseas when I was in Germany was a guard for Elsa Cohen at the Nuremberg trials. And he told me exactly what happened to some degree. She became pregnant because she was a nymphomaniac and was a screwball. She had some kind of problem. She really had a problem. But she was also a very beautiful woman. She used to parade naked in front of her troops. And she tattooed beautiful designs on the backs of human people. And I was telling this story in a truck stop in Portland, a very famous truck stop called Chubas.
Don't.
And a guy,
Hold the line. Don't hold the mic.
a guy there, I'm sorry, was standing over there, and everybody said, "You're crazy. You don't do things like that." She tattooed these things on your back and then sit you down, give you your skin off.
I'm sorry, how is this relevant? I'm sorry, how is this relevant? We have 4 more minutes of tape. I'm sorry to bust your bubble there, but
I didn't hear what you said.
good.
How is it relevant?
How is it relevant?
Yes.
How's it relevant? It's going to happen right here.
Her tattoo?
I believe it's going to happen
Her
right
tattoo is relevant to what's going to happen here?
here. Oh, what happened to that?
No, why is it relevant to what we're talking
The
about?
same thing's happening right now. The same process going on right now, the same kind of people.
All right.
That's what makes it relevant.
Good. 9, 8.
Okay, so
We're on.
we're on. So a gentleman here has raised an issue, and that is regarding motion in limine. And I'm going to pass out, get passed out it. I've got to go to the computer and find the response. But basically, motion in limine is a relatively recent invention, and the prosecution just loves to use that crap. I could share with you a quick little story. So I have a friend, and we've been friends, I guess, for about 15 years, and that is maybe known to you as Constitution Man or Carl Miller. Anyway, he's visited me in Texas, and I visited him in Michigan, and we're good friends. There was a time when he was basically on his deathbed with Agent Orange poisoning. He did, I forget how many, 3 or 4 tours in Vietnam. So he was terribly ill, but there was a radio talk show, and Alan Dershowitz was on the radio talk show, and extolling the virtues of motion in limine. So Carl Miller picks up the phone, calls in, and reads Dershowitz the riot act, and just tears him up. And Dershowitz says to the talk show host, something to the effect, you set me up with a ringer. I'll never speak on this talk show again, never. Because he got tore up by Carl Miller. And anyway, I got that stuff in the computer, and we'll pass it out to everybody, because it's one of those things that in the process, people go into the courtroom and they think this is a court of justice, and that they're seeking justice, and then they get overwhelmed because there is none of that. And it's just one shyster shenanigan after another, and motion in limine is just one of those shyster shenanigans.
How do you spell that last word?
Limine.
What is the exact one? Lemon.
Okay, it's to limit what you're going to talk about, or that you're going to question the witnesses about.
It doesn't let you present your defense.
Yeah, they try and cut off your defense, exactly correct. You know, so this last May in Cherokee County, they were bringing this felony charge against me. We went to trial, and the prosecution had this motion in limine, and I kept going outside and, you know, and doing my thing. The judge threatened me, in the first day, he threatened me like 20 times with jailing me or, you know, for contempt. And to the effect that, you know, I'd be in the courtroom with chains and irons on me. But I had to do what I had to do, and in the end, they didn't get a victory that they figured they would. And they did more than just motion in limine. In Cherokee County is the only one I know of. That there's actually a website that documents their corruption on an ongoing basis. And so that, I got in touch with the webmaster, who is anonymous. And he's not in Cherokee County, but he certainly has contacts because he knows what's going on at all times. And I still don't know who this guy is. I really don't even know whether he's male or female. Anyway, the thing is that I go to trial, and there's a jury, and the jury was deadlocked, and it was a mistrial. So after that, this webmaster contacts me, and he informs me that at least 3 of the people on the jury were plants by the prosecution. One of the people on the jury was the son-in-law of the sheriff. And he also happened to be a Baptist preacher. Well, I could just imagine somebody who's used to public speaking, son-in-law with the sheriff, and a preacher, could be a powerful influence in the jury room. And one of the others was a young female, and her father worked for the Jacksonville Daily Progress newspaper as a sales manager. And their circulation was up with all this stuff about me, so they were running a continuous propaganda program against me and always kindling the fire and making it bigger, okay? So, and they listed as the top stories of the year, I was the top story, okay, in their podunk little newspaper. So, you know, and the sales manager's daughter is on my jury. How about it? and then the third one was, you know, I showed you all the picture of the building. On the block, on the next block was a woman who's, you know, socially influential, has a restaurant called Larissa House, and across the street is the police department. Well, various people had mentioned to me that she wanted that building, and that it's the reason why I had so many problems. You know, just immediately after the real estate closing comes 3 SWAT attacks. And anyway, the banker, her, that she's associated with, some banker, was on my jury. Coincidence. So, you know, this is the kind of thing that the webmaster on the corruption told me in his message, that this is routine with the district attorney in Cherokee County. So, Yeah, I'll make a copy of the motion and limine response on that. And like I say, I just plowed ahead in my case and let them threaten me all they wanted.
I thought you mentioned that you could take it off record and get the jury out by some kind of a bill of something or other, and I don't remember what you called it.
Yeah, that was, we did that and two issues. My friend Brady helped me out, and he does a lot of this stuff with the Public Information Act. So, and Brady dug up the information. We had a lot of evidence, and it was that none of the police were valid. They didn't have their paperwork done right. There was not a single police officer that was right. The city had never created a police department, and the mayor wasn't properly in office. City manager wasn't properly in office. None of the city council were properly in office. The whole shebang was completely bogus. Everything. And of course, they motion in limine. They didn't want that stuff in the courtroom, and they were refusing Brady's testimony. And they said, we want to do a bill, and the judge finally relented on that, and so we got Brady on the jury out of the room. You know, we dismissed them for the day, and then we put Brady on, and all of that evidence is in the file. Then we also had Eddie Craig, and for those who don't know Eddie Craig, he works with Randy Kelton, and he had been either a deputy sheriff or a highway patrol or something. Anyway, that guy knows the Texas transportation code frontwards and backwards. We can tear him up on all of that. And we had his stuff brought in as a bill as well. So yeah, you could get around their tactics, and that's a very good point. I'm glad you brought that up. That if you have evidence that they just absolutely don't want to let in, say, okay, have the jury out of the way, and we're going to put it in a bill, and you get your witness on the stand, you get your evidence in, and it's preserved for appeal, even though the judge is saying he's not going to listen to it.
And what do you call that bill?
They just call it a bill in Texas.
Okay.
Is it a bill of particulars, or?
No.
That's the West process.
That'll do an end run around the motion and limiting.
Well, to an extent.
What is the
but
question?
the real end run around the motion and limine is the stuff that I was going to have done up for you. And none of this stuff, you understand, you know, what's being presented here is things that can work, but you can run into a lunatic judge who, well, okay, Dr. Brooks, for instance. Okay, Dr. Brooks studied out his stuff, and he had Supreme Court cases backing up his position. Now, he was in front of a judge by the name of Bentley. This guy is worse than anything you could possibly imagine. And, I mean, they know even in the courthouse that he's virtually certifiably insane. So, Brooks presents his stuff, and Bentley says, well, I don't think the United States Supreme Court said that, so that's out of here. You know?
We got the same time here.
You know, I don't think he said that, so that's finished. It's out of here. Just unbelievable. You know,
You still have to get it.
I mean, Brooks is there testifying to this stuff, and you know, I mean, I guess Brooks was probably too stunned, and the rest of us too. I mean, what they did to me, by the way, at Brooks's trial is they had me arrested in the middle of his trial so that I couldn't help him. The prosecutor claimed that they had a warrant for my arrest. Two bailiffs took me out of the courtroom, you know, to another part of the courthouse and sit and wait, you know. And there was no warrant for my arrest, even though the prosecutor, the district attorney said there was. And by the time, and they called the U.S. Marshals, and those guys came down, and they said, well, Mr. Fox, you sent a letter to a judge in Wisconsin. And I said, yeah. And they said, well, did you intend to threaten the judge? I said, you know, this is at the time, okay? They said, look at me, I'm blind and I'm crippled. Who am I going to threaten? I'm like Mr. Magoo, you know? And they laughed out loud themselves, you know? And so anyway, they said, well, Mr. Fox, we just, you know, have to check on these things to make sure it isn't a threat. And I said, no, it's no threat at all. See, like, you know, like the judge, for instance, in Tyler could say that I had threatened him because I said that man-stealing, the punishment for man-stealing is death. But you can't take things out of context. I said the punishment in the Bible at Exodus 21:16, the punishment for man-stealing is death. So I didn't threaten the judge with death, just informed the judge that the Bible says that's death. Right? I didn't threaten to kill anybody. And from my perspective, I've already seen it. You know, 2 officers that arrested me in separate incidents, separate arrests and separate incidents for them because they were in different places. You know, one of them got turned to mush on the freeway. Just smacked with a pickup truck and blown to bits.
Good.
So, you know, that's what they get. I mean, they do evil, and then, you know, our Heavenly Father just whacks them. It's just the way it is. No threat at all. Carla raised the issues of subpoenas, and that you subpoena certain parties, and like I said, I subpoenaed the reporter from NBC. When I subpoenaed the reporter from NBC, that was a television station in Tyler, Texas, and Jacksonville's 30 miles south. Not that that's a big deal, but they got attorneys from Houston to respond. And the attorneys from Houston put in a motion to quash my subpoenas. Now, that's the kind of thing that happens, okay? So you have to be sort of prepared for that, and you have to be able to justify, like, the relevance of their testimony to your case and things like that. So, you know, they don't let you just harass all kinds of people out there. It has to be something reasonable, that you can make a connection between their potential testimony and your case. And that's how that goes.
I have one question. The state is always the plaintiff in every action. Can the state be subpoenaed?
That's a real good one now, isn't it? Okay. The state obviously is a fiction. It's a piece of paper. But you could potentially subpoena the Secretary of State. You could potentially subpoena the governor. And you could subpoena the legislative record as to the law and various aspects of that. And then in your local area, wherever that might be, you know, the district attorney, his assistant, they are allegedly representing the state. And so you possibly subpoena them And some of this stuff, these subpoenas, if you subpoena the right people with the right issues, they may drop your whole case right there on that alone. Because when they know that you're headed to a certain direction and that you could potentially beat them and cause a big problem with, because, let me say this, the trial court judge may be able to try and run over top of you, but then, like Mike has said, you do a bill, and that's what I did with Brady's stuff and Eddie Craig's stuff, to preserve it for appeal. But then, of course, the jury was deadlocked, and it was a mistrial. But you have to do the best you can to get the evidence that you need in, subpoena the right people, ask the right questions. If they don't want to let you get it on the record, you get it in any way with a bill, and you take it the distance. And they will get scared if they do like real dirty work at the trial court level. They don't like for the appeals court, their bosses, to be looking at what kind of jerks they are and how ignorant they are. They held me in Cherokee County, they held me beyond the legal limit. And boy, they didn't want to talk about that one. Because my take on it is they got no excuse. How can ignorance of the law be an excuse for the judge and the district attorney?
Would you consider subpoenaing the Secretary of the Treasury in an IRS case?
Yeah, I would.
My question is, so often when suits are brought against,
You want to come to the microphone so
am I loud enough?
Yeah.
No, go to the microphone.
go ahead.
My question is, when a suit's been brought against you, 9 out of 10 times it says United States of America.
Okay.
And my question is, can we subpoena the United States of America? Or who is the United States of America? Who is the real party of interest? Who has the first-hand evidence? And I can't get through any of this stuff because no one has. You're kind of trying on presumptions with a mysterious witness that you can't seem to find.
The United States of America in 3002, Title 28, is a corporation.
That's right. That's United States, though, not the United States of America. Right, it's United States.
The United States is a corporation.
All capital letters.
Right, just the United States only.
Right.
Because when they bring out the president, he doesn't say of America, he says United States.
Look it up on Dun & Bradstreet.
This court case, the United States of America, and it's upper lowercase.
Wow.
So tell me who it is.
Yeah.
Well, and now that you mention that, make something here.
But isn't that true just about in every case? It's all based on presumption, and there is actually no witness against you in just about every case that you can possibly be charged with. Isn't that the fraud that goes on?
I agree.
Yeah.
Agreed.
Yes.
Go ahead, finish writing. And then I
Okay,
have a
just got
question.
one little more bit here to do.
How many people are here from Maricopa County? I'm trying to get an idea so we can maybe go into what we can do get the county recorder to start acting right.
In regards to the notices?
In regards to putting anything in there.
Recording.
I got something.
Unless it's got some.
If I can find it.
You have to, if they deny something, you ask them what the remedy is, and they have to give you that to tell you how to get the document filed.
Actually, that part doesn't even matter. I'll have to find the reference, but apparently this works the same in every state, and I got this information from Howard Griswold, who's a phenomenal commercial remedy person, but it's pretty difficult to get information from him directly. But in any case, in the state of Arizona, and supposedly in every state, if you have filed your documents and you have provided the appropriate fee for it, legally it is considered recorded. So the way you do it is you don't go there personally, because you'll have problems with them getting to accept it and all that. You put it in the mail, send it registered with the fee, and even if they do reject it, by law, it is considered recorded as long as it meets whatever recorded requirements they have.
No, but
As long as, that's the problem. That's,
hold on.
On microphone.
The requirements that they refer to are not arbitrary. They are very specific. So one of the examples is if the appropriate fee is not provided, they don't have to accept it. One of the other ones is if it's a financial statement, it has to list the debtor, the creditor, stuff like that. Those are the kind of exceptions that that say that they can reject it. So there are very specific requirements that have to be
That will be
met.
listed in the statute.
Right, they'll be listed in the statute, and after you read them, you'll understand that they can reject it for other reasons, but if one of those reasons is not one of the ones listed in the statute, then it's considered recorded even if they do reject it.
With a third-party witness.
Registrations.
You said that you didn't want to do it yourself, you'd have somebody else do the mailing.
Right, well, no, you can do the mailing yourself. See, the problem is a lot of the complaints are that when people go, like, say, with their freedom documents or whatever they're trying to file, that they go there personally, the recorder looks at the documents and decides, well, I don't want to file these, and then you're kind of stuck. So to get around that, what you do is you mail the documents. They receive them in the mail. You send it certified mail, so you have a certificate that they have received it. And as long as it contains the fee and whatever recording requirements that are supposed to be in there, even if they reject it, at that point it is considered recorded legally, even if they don't record it.
It's notice.
So how do you get a certified copy of that recorded document?
You don't need,
You got that?
the distinction is it's considered recorded once it's received with the fee.
I got it. But
That's
how do
it.
How do I get a certified copy to take into court? The whole reason I'm filing it.
No, you don't need a certified copy. The only thing you need to verify or certify is that they received the documents.
So you need a witness.
You attach it.
The witness-
witness.
Right, the U.S. Postal Service is the witness.
And the document you file, you put the certification number at the top of the
You
document.
don't have a certification number. They
You
give
write
me
it in the document.
one. They have to give me one.
No, it's certified.
Yeah, you send it certified mail, and when they receive it, the U.S. Post Office sends back that certification, or you can get a copy of it on the internet or whatever.
It doesn't meet
But-
the rules of evidence under 901, 902, and 903. How are you going to get into court?
if they reject it, write them a letter back and ask them what your remedy is. They have to give it to you. A lot of times they will tell you to change the title or something like that, then send it back to them and they will record it.
I like that.
Yes.
Does that work? Have you had it work?
Yes, I've known two people that it's worked for. So if they deny it, write them a letter back and ask them what the remedy is, and they have to give it to you.
Because we've actually filed documents that they've accepted, and 4 days later, they've returned it with a check saying we no longer record this. We voided it.
Robert, I have
Yes.
a question. Back to subpoenaing, like the governor, secretary of state, what, et cetera. What kinds of things could you subpoena from them in, say, like a traffic case?
I'm making a note of that right now,
Okay.
because I don't have those documents with me, but I can email you, and I might as well at the same time everybody,
Okay, I would like that.
you know, so.
We don't want any just email between you two, you guys, you know?
You got 17
Ex parte
minutes.
email.
Ex parte emails here.
Okay,
It's a quarter of 12 for your information. We've got plenty of tape, so. But if we're gonna stop at 12.
Group picture.
The actual statute for Arizona revised statutes, it's Title 47, and it's 9516. It says, except as otherwise provided in subsection B of this section, communication of recording to a filing office and tender of the filing fee or acceptance of the record by the filing constitutes a filing.
Or the acceptance, that's.
They signed for it. That's the
Right, but,
signature.
right.
Well, that device is not allowed in the court and it's hereby confiscated.
For those people that have a federal case, they'd be interested in this, but something similar happens in the state anyway. This one here along the top, with the district court in lowercase, this district court was created by the Judiciary Act in the 1700s. Okay? And now you'll see that they do their oaths and other stuff in this court, but you get tried, you know, they'll come against you in this. Now, it's an interesting arrangement because, well, let's say this. In Tim and Don's IRS case, the jurisdiction issue was challenged, and the judge's response was that they had jurisdiction, and he cited numerous cases, and they were all this, okay, the one that was created by the Judiciary Act. Only thing is, this is the one that's trying Tim and Don.
Did you bring that up to them?
Oh yeah, we're you know, we've got stuff that, you know, again, I can send you that stuff.
Do we have access to those pleadings?
Absolutely.
Through you?
Yeah.
We got connections?
Yeah,
Good.
you got connections.
All right.
You're a good guy, and yes, you got connections.
All right, good.
That material will be available on Pacer, would it not,
Yeah,
for their case?
yeah. Yeah, because the stuff has gone back and forth. Of course, it's been a hell of a battle.
I'd be willing to download it and put it up on my website for everybody to go look at the documents if you want. So I'll get the case number from you. Sure. Yeah. I just stick it under there, like a lot of the other cases.
Which website?
ResearchSociety.org.
What is it?
ResearchSociety.org. And there's a bottom that says cases, and I'll put it under there.
What's it
That
for?
sounds to me like you're proposing
Thanks, Terry.
collaboration.
Tim and Don. I'm giving you.
Yeah, we'll get the case number to that.
So,
How do you hold the judges accountable for breaking law? I think that's the biggest issue everybody has here.
okay, there's a,
What's the remedies we have for that?
you can do a complaint against the judge or any attorney, and, you know, the bar complaints, they would appear to do nothing about them, and that's pretty well correct as far as the bar goes. But all these attorneys have to be bonded, and when they get their third complaint within a year, they can't get bonded, and that takes them out. So that's,
Third complaint from 3 different people? Or 3 different incidents?
could be 3 different incidents, one guy, I suppose. It's the third complaint, you know? And And then with regards to federal judges, my friend Michael Brown had 2 federal judges removed from the bench. And the way he did it, this is really good, because you can complain about federal judges and you're not going to go anywhere. But what Michael Brown did, because he's teaching seminars and such, he would take a part in the seminar, and he'd have a table set up, and he'd have some of the pleadings on the table so that everyone could come and look at the stuff. And I guess he had the right parts highlighted or whatever. And so you could look at the pleadings and see what went on, and then you could fill out the complaint from you and send it in to the Senate Judiciary Committee on judicial conduct. And he didn't have like 1, 2, or 3 complaints going in. They were like 2,000 or 3,000. So you can imagine they have like personnel files, just like they have, the police department has personnel files under cops. And, you know, there's a difference. If the guy's got no complaints and his file is pretty thin, you know, but if somebody's got a wad of complaints, then you can imagine when it hits 2,000 or 3,000 complaints, it's a block. And he, you know, blew off 2 federal judges that way, right off the bench. Like they weren't just, I think they were gone. So you could do complaints like that. And another thing is, you might want to look at Randy Kelson's website, and there's criminal complaints there. And when you know, bring criminal complaints against them, you may or may not get the handcuffs on them, but you'll sure get the system riled up about the situation. Yeah, you get their attention. Harlan?
It's my understanding from a reliable source that you go after them on not what they did do, but what they didn't do.
Okay.
Dereliction of duty, you talked about.
Breach of duty?
That's
Yeah,
what
it's
I would-
easier to prove
I
the
think-
concept, it's easier to prove something
Yeah.
they did not do and they were supposed to, than you have to prove that which they did. It's much easier. Based on their performance.
I think what that means is by stating what they did not do explains the violation of law that they broke.
Makes sense.
It was actually a judge that told me that, and it wasn't elaborated on. Just what I was told, the exact words were, because I asked the same question, and I was told you get them on not what they did, but what they didn't do. That's how you get them.
That makes sense, because it's like, this is the law, and they
So
didn't do
take
this.
it for whatever it's worth.
And how are we doing time-wise? Oh, okay.
So it's 11:52.
But we got plenty of tape, right?
Yes.
We have 30,
So we-
37 minutes left.
Okay. Did you want to take lunch at 12, or we just go for the 37 minutes and then take lunch?
Be good.
Okay, good. That's fine. So,
You want to distribute those?
okay.
Is that,